Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called Fingerprint Evidence. It's designed to assist legal practitioners in the Local Court of New South Wales. A few years ago, I had a case in which a client of mine was charged with larceny of a car number plate. A car had been stolen, and later on the police recovered the number plate from that car attached to a different car. So they analysed this number plate, and on the back of it, they developed one fingerprint which they matched to my client. Now, most lawyers would say that that is a pretty strong police case, and they would say that my client is in big trouble. In fact, they might say he's done like a dinner or he's gone to Gowings. So they're often very surprised when I tell them that, in fact, the charge was dismissed. The magistrate found that there was no case to answer. Now, I achieved that acquittal without challenging any of the forensic evidence. In fact, I allowed the police to tender the entire brief without objection. And this includes the fingerprint expert's report, and I didn't even challenge that the fingerprint was in fact that of my client. However, I did challenge what inferences could be drawn from that fingerprint. I pointed out that the burden of proof fell on the police to prove every element of a criminal offence, and that includes showing that my client appropriated the property and also that he was acting dishonestly at the time he did so, and that neither of these elements could be proved simply by fingerprint. The fingerprint proved that he had touched that object, but you couldn't make a finding of fact that he had appropriated or was in possession of that object, and you certainly couldn't infer that his state of mind was that of dishonesty when he did so. Now, in making that submission, I relied on the English authority of Crown Court. In England, a car had been stolen and later recovered by the police, and the police developed a single fingerprint on the driving mirror, which they matched to Mr. Court. Now, Mr. Court was tried before a jury, and the jury convicted him of stealing the car. Now, Mr. Court, of course, appealed to the Court of Appeal, and the Court of Appeal in England quashed his conviction. The Court of Appeal held that there was no sufficient evidence of possession of the car by Mr. Court, and that the case should have been withdrawn from the jury at the close of evidence for the prosecution, and that the conviction had to be quashed. The fingerprint founded the inference that Mr. Court had been inside the car, but it could not by itself found an inference that Mr. Court had been driving the car or that he'd been in possession of it. And even if it could, then there was no evidence that he was acting dishonestly at the time. So the charge against my client was dismissed, just as the conviction for Mr. Court was quashed. Now, when I tell this story to people, they're always surprised and shocked, and if they're not lawyers, they often say, look, how can that be? It looks extremely dodgy. Doesn't your client have to explain how his fingerprint came to be on the number plate? And the short answer is that no, he doesn't. In England and in Australia, no one is required to answer police questions and not required to give an explanation, and no adverse inference can be drawn from that silence. And that was a principle under the common law, and today it is entrenched in statute in the Section 89 of the Evidence Act. So my client refused to be interviewed by police, and he was never asked to give an explanation as to how his fingerprint ended up on that license plate. And that brings me to the final part of this video, which is about DNA evidence. Now, all the principles that apply to fingerprint evidence also apply to DNA evidence. Many lawyers are very afraid of DNA evidence. They think it's irrefutable and it will be very persuasive to a jury or to a court. But the fact is that while DNA on a particular object might found an inference that your client has touched that object, it doesn't say when they touched that object or that they were in possession of it or that they were acting dishonestly at the time. So the same limitations that apply to fingerprints also apply to DNA evidence. But in one way, DNA evidence is actually less reliable than fingerprints, and that's because of transference. So if I were to touch an object and leave my fingerprints on it, that would prove that I touched the object, but my fingerprints can't rub off onto a second object, whereas with DNA, they can. I might touch the first object comes into contact with the second object, and my DNA is transferred. So for that reason, DNA evidence is less reliable than fingerprint evidence, and whenever you receive a case that has fingerprint evidence or DNA evidence, you should be analyzing the elements of the offense and asking yourself, can this fingerprint by itself or this DNA by itself found an inference of every element, including state of mind? And usually it can't. Thank you for your attention.